order. Welcome, Minister. I believe it's your first appearance at the Scottish Affairs Committee.
I think it is. It's a very great pleasure to be here.
It's as much a treat for us as it is for you, so we're very grateful for you to help us out in our agriculture inquiry. We thought it was important we were able to speak to you as the bill is going through, so we're grateful for your time, and I know you're very busy consumed with the bill just now. Just for a record, of course, who you are, who you represent, which I think we all know, and anything by way of a short introductory statement.
Right. So I'm George Eustice, the Minister for Agriculture, Fisheries and Food. We're in the middle at the moment of the committee stage of the Agriculture Bill, which makes provisions for, as you'll know, predominantly for England in the main body of the bill, but there are some issues that are reserved UK matters, and I'm sure those are ones you'll want to discuss. There's a schedule in the bill that deals with powers that the Welsh Government have asked us for, and another schedule for powers that the Northern Ireland DAERA have asked us for. At the moment, there isn't a provision in the bill for the Scottish Government, but we know they're still considering their position.
Grateful. Well, that was very concise, and thank you for that. I mean, just to get things started, can you just confirm that agriculture is totally and utterly devoid and is a responsibility exclusively for the Scottish Parliament and the Scottish Government?
Yes, agriculture policy and the schemes that are put in place to support agriculture, that is to say what replaces the common agricultural policy as it exists, those financial incentives are fully devolved. There are, though, obviously elements that pertain to competition law or international obligations such as the WTO, which are reserved. But the basics of the policy is yes.
The nuts and bolts of farming and agriculture in the rural economy is exclusively,
and the way we support them is devolved.
It's a matter for Scottish parliamentarians to design the Scottish Government to ensure that will be carried through and implemented, as long as I get that clear. So, therefore, it is not necessary for the Scottish Government, Scottish Minister, Scottish Parliament to be included in any schedule in this bill if that's what they choose.
No, it's not a requirement. The alternative is that they bring forward legislation through the Scottish Parliament.
And do you understand the very clear reasons why Scottish ministers feel that they're not obliged to participate in this bill just now? Do you understand the concerns that they have? Do you recognise them? And what would be your response to the very real concerns that they have, what they see in terms of limiting their abilities to ensure that they have got full control of devolved responsibilities?
Well, as I understand it, part of their objection is a broader principled one, in that I think following obviously disagreement over the EU Withdrawal Act, as I understand it, the Scottish Government has taken a sort of general policy position, which is that they will withhold legislative consent motions from all so-called BrExit bills, that's bills that pertain to BrExit. But underneath that, they then raised individual issues around this bill, predominantly around the section on the WTO compliance and on producer organisations, and thirdly on some of the provisions on other areas of competition law, such as provisions for fair dealing and fair trading.
And I know you acknowledge the issues that they have. Do you understand and respect the problems that the Scottish Government have when it comes to this? And what are you doing to try and ensure that we could get beyond this and ensure that possibly if the Scottish Government do decide to accept a schedule, this would be possible? What are you doing to try and resolve these things?
Well, look, we've got an ever-open door in terms of having a dialogue and a discussion to try to work through those differences. But I have to say that we do disagree with them for the following reasons. Compliance with a WTO schedule, currently that's done by the European Union, and there are EU requirements that the UK and parts of the UK have to feed into that process, submit data to the EU so that they can demonstrate compliance with an EU WTO schedule. In future, there will be a UK WTO schedule, and in particular when it comes to what's called the aggregate measure of support, that's the so-called amber box allowance, there's a UK-wide envelope, and somebody needs to take responsibility for demonstrating compliance with that, and that can only really be the UK government. So compliance with the WTO provision we think is clearly reserved and can only be reserved, and no other basis would work. Secondly, the bit around producer organisations, that is a derogation from competition law, and competition law is also very clearly reserved. So while we're always respectful of the positions that the Scottish Government raise, and we will always engage in dialogue and discussion to try to reach a common understanding, and we appreciate they've got some legal advice that they've presented, it's advice that we disagree with as a point of the devolved settlement.
Well, I'm grateful to hear that, because that's exactly what we heard from the Cabinet Secretary yesterday, that there was a whole load of work going on just now to try and come to some sort of an arrangement and agreement which would get us beyond this particular impasse. Now, tell me if I'm right with my understanding of this, that WTO arrangements relationship as part of international relations is totally reserved, and nobody disagrees with that. I think that that's the view of the Scottish Government, certainly the view of this Government. But the implementation of WTO arrangements and agreements is a matter for devolved governments. Is that also right?
So it becomes a very close thing. So what is true is that under the devolution settlement, the devolved administrations are obliged to observe our international obligations. Yeah. The issue is that the provisions that we take in this bill are around basically demonstrating compliance with that. So it's less about the implementation, more about the compliance. And then there's just a particular problem around the amber box. We intend to have in our WTO schedule an amber box provision that will be a carve-out from the existing EU one, that will be in the region of around £3 billion per year. And that will be the maximum envelope for the whole UK that the UK in aggregate can spend on types of farm support that might fall outside of this or that WTO rule. So the difficulty is a Scottish Government will not know whether it is compliant with the WTO rules, because there's a UK-wide envelope. And just as the EU currently takes responsibility for demonstrating EU compliance with its amber box envelope, in future the UK Government must have the tools to be able to demonstrate that it's complying, and if necessary ensure that we collectively as a UK have certain ceilings on market distorting support so that we do comply.
So again, this would be a matter for the UK assuming the responsibilities and powers that currently rest with the European Union. That you're assuming that, and the dispute seems to be about the implementation of these particular arrangements and the reporting to the UK. Now, what we heard yesterday from the Cabinet Secretary and from National Farmer Union of Scotland was concerns with these new powers, which would be vested with the Secretary of State, would mean that there would be a limit on the amount of support that the Scottish Government would be able to give to Scottish farmers if they chose to do that. Again, is that something that you recognise?
Yes, but the only remedy to not having that support is to quit the WTO as well, as a UK. So if we're serious about remaining a member of the WTO, and I think we are, I think it's only North Korea and possibly one or two other countries that are not in the WTO, and we're committed to that sort of international rules-based order. If we intend to remain in the WTO and abide by the provisions of the WTO, only the UK can demonstrate compliance with it because we hold that AMS envelope. Yeah. So just as at the moment, the way the system works at the moment is that there's an organisation called the UK Coordinating Body, which is a small unit of people that it resides at the RPA, within the Rural Payments Agency, but which has connections with all of the devolved administrations. And they, on behalf of the UK, collect all of the relevant data to demonstrate our compliance with WTO provisions. And they then submit that to the European Union. And there are legal obligations on us as the UK to submit that information to the European Union. And the European Union then complies the records that it needs to demonstrate compliance EU-wide with the WTO. And so all we're really trying to replicate here is what's a current requirement on the UK to submit data to the EU. When the UK is directly responsible for its own schedule, we have to have some provision to collect that data and enforce that compliance and demonstrate that.
But that's all fair enough, and I think that's my understanding too. But is it the case that you understand, therefore, that it's the responsibility as a devolved arrangement, that it's the Scottish Parliament that is responsible for implementing these arrangements? They have the full power and the full range of responsibilities to do that. Is that your understanding?
Yes, except they can't know, so they have to abide, but they can't.
What do you mean they can't know?
Well, they can't know. So if Scotland, hypothetically, if Scotland decided to do a number of schemes that were that basically breached the aggregate market support envelope, or took, for want of a better term, a greater share than should be theirs. So if they spent all of their money in Amber Box, they would then be effectively busting the envelope that we had, and would therefore compromise Northern Ireland, England and Wales to be able to do the same. So it's really simply a case that somebody has to be able to apportion the amber box fairly.
And that would be the Secretary of State exclusively.
That has to be the Secretary of State.
Right, okay. And I think that's where the conflict seems to be with the Scottish
Yes.
Government. And again, they've got legal advice, and we've also seen legal advice from NFUS Scotland, which sort of challenges that particular view. But I know there's a couple of colleagues that want to come in. First, Tommy Sheppard, and then Kirstene here.
Good afternoon, Minister. Just to press on this point, would I be right in saying then that your intention in taking the powers in the bill to be able to set a ceiling on agricultural subsidy is to ensure that the aggregate amount UK-wide conforms, rather than to insist that the agricultural subsidy ceiling has to be the same in every part of the United Kingdom? Would that be fair?
Yes.
So it does allow for deviation or difference between, say, Scotland and England?
Yes.
Okay.
And so I think...
Well, in which case, if that's the case, that it's not to ensure conformity within the UK, but compliance with an international obligation, why then would you not consult with the Scottish and Welsh Parliaments and the Northern Ireland Assembly in determining how that ceiling should be implemented?
Well, in practice, obviously, there would be a discussion about that. But the issue we have...
But it's not in the bill.
No,
you alone will have the power to set the ceiling.
Well, I'm trying the precise wording. There is a dispute resolution process in the event. I'll have to look up the. So in clause 26, subsection 2b, a process for the resolution of disputes between the appropriate authorities regarding the classification of domestic support, can be set up. So that there is already a provision for a dispute resolution process should there be a disagreement within the UK about how the AMS envelope is carved up, or indeed how a particular type of support might be classified.
So do you see that clause as qualifying your ability to act in terms of setting regulations?
It sets up a dispute resolution process, but it does also say, obviously, that the Secretary of State may have to be the final arbiter, and I think that's right, and that's consistent with a process of consultation, where at the end of the day, if there's a disagreement and we're unable to reach agreement, someone's got to make a decision. It should be the one who holds the schedule.
Do you not see a conflict of interest then between you as a DEFRA minister, fighting the case of English farmers, and being the final arbiter in any dispute?
I don't really know, because I deal with this kind of thing all the time. Every year I do December Fisheries Council. I approach it as a UK minister when we're talking about the context of international obligations and international agreements. You very much do so as a UK minister. And I think in my 5 years in this job, I've run up against many of these things. We've always tried to be fair and balanced and strike the right balance for each and every part of the UK.
Okay, Kirstene here.
Thank you, Chair. Good afternoon, Minister. Just to clarify a point that was picked up yesterday, we had NFUS, Environmental Link and the Crofters Association, who all suggested that farmers in Scotland were begging for clarity around Scottish agricultural policy. But being part of this bill wouldn't stop the Scottish Government from creating their own agricultural policy. Would that be correct?
Absolutely correct. And so the Welsh Government have already signalled to us that to all intents and purposes, they want a carbon copy of our bill in Schedule 3, because they think it gives them all of the powers that they need in order to be able to pursue their policy agenda. But Lesley Griffiths has equally made clear that they see this as a holding position, and that at some point in the future, maybe sooner, maybe later, depending on what's needed, they intend to have what they call a Made in Wales bill that will go through the Welsh Assembly. So their approach has been to say, time is of the essence, we're in a period of great change, let's bank the powers that we've developed, because it enables them to do most of the things they want, but that at a certain point in the future they will then replace that schedule with a piece of legislation of their own through their own assembly.
Okay, thank you. And if the Scottish Government does not get involved in this bill or secure a passage of its own bill in Holyrood by exit day, do you believe that Scottish farmers can be rest assured that their payments will continue as normal, or do you think there might be issues around those payments?
No, at the very least, and it would depend on, this is a complex area, if there is a no-deal Brexit, so there is no implementation period and no withdrawal agreement, then they would be able to make payments for the 2020 scheme year, But then the regulations in the retained EU law have a natural sunset clause built into them, so they wouldn't have the power to pay farmers in 2021. So they would have to, at the very least, introduce simple clauses to be able to give them the power to make those payments by 2021 in the event of no deal. However, if there is a deal, the way that the current withdrawal agreement has been put together is that regulation, the EU regulation that underpins the current payment, would actually be revoked and replaced with a different set of arrangements. And in our case, it's the agriculture bill that will then give the authority to pay. The same is true for Wales and Northern Ireland. So in a deal scenario, Scotland would lose the legal power to be able to pay farmers in 2020. So they'd have it for next year, but not the year after.
Okay.
Now, they could remedy that, and we have clauses that we are putting into our bill. If they just wanted that simple fix, they would have to have the powers to be able to set what's called a national envelope for Scotland, which is effectively a power to allocate a budget. And they could do it probably with a few simple clauses, but they would need primary legislation to do that.
So yesterday we had Cabinet Secretary Fergus Ewing who gave evidence to this committee, and he clearly stated that obviously the Scottish Government, as we know, were unwilling to be part of the bill, and he suggested that the Scottish Government have a legal mechanism to make payments to farmers. Now, what he offered two suggestions. One was through the withdrawal bill, which we've already identified would only be the case in a no-deal scenario based on your previous question, and his other option was through the continuity bill, which has not yet received an outcome from the Supreme Court. So surely these two options are actually not particularly valid, and would you suggest that is of great concern to Scottish farmers, that in fact the Scottish Government don't have a process to make payments?
Well, my understanding from NFU Scotland, who gave some evidence to the committee stage of the bill and who I've met recently, I think they would prefer the Scottish Government to have some kind of schedule in the bill, so that there's at least some kind of certainty, even if it's for the short term. I mean, we're prepared to add whatever schedule the Scottish Government might ask us to, but we obviously won't do it unless they do. But the options for them range from doing something similar to Wales and having a temporary carbon copy of our bill in a schedule, doing something like Northern Ireland, and Northern Ireland have chosen to just bring over the powers to continue the existing BPS system and to be able to reform and modify it so that no dramatic change, but an ability to flex the status quo. Or the final thing would be to ask us to simply put in a schedule that gives them, at the very least, the power to be able to make payments on a completely unreformed scheme. And we could do any one of those three things if they wanted, or if not, they have to find a suitable legislative vehicle through the Scottish Parliament. But you would say that at the moment there doesn't seem to be a suitable legislative vehicle through the Scottish Parliament? Well, obviously the Scottish Continuity Bill, as it's called, has been that's been challenged. It's going through the Supreme Court at the moment. I know that I think even the presiding officer in the Scottish Parliament was very sceptical about this, and they went against his advice for the first time ever. So there's certainly a big question, I think, over that particular piece of legislation. So if that were to fall, they would have to identify an alternative vehicle to do that. And they haven't done that to yourself or any other ministers, or indeed the Cabinet Minister for DEFRA? Not at the moment, and my understanding is that Scottish Government officials do understand this nuanced difference between if there's a deal and a no deal, and that if there is a deal, their legal powers to pay fall down in 2020. Thank you.
Let's hope there isn't a no deal, because then we're in a real crisis situation. Some of the incredible tariffs
maybe
that our farmers will be confronting.
Banking on a no deal, and then they have to...
Just to clarify this point, I mean, you do agree with NFUS Scotland and the Cabinet Secretary that of course there will be an ability to pay Scottish farmers. There's no question about that.
They would have to find. They'd have to
but
put in.
It could be done. Yeah.
It could be done.
Right.
Yes.
That's fine. Because yesterday we spent an awful lot of time discussing this, and there was a number of questions raised about this. As long as you agree that can be done.
It could be done, but it doesn't. It needs primary legislation.
I know there's lots of qualifications in your view about how that should be done, but you agree it could be done. So that's helpful. Deidre Brock.
Thank you, Chair. Very quick question, really just about, and I should declare an interest, of course, as a member of the Agriculture bill, as the Minister knows. But at the Agriculture Bill Committee meeting yesterday, we discussed Amendment 90 to Schedule 3, which is the Welsh schedule, which, if passed, and thankfully it was only a probing amendment at this stage anyway, would have restricted who the Welsh Government can make payments to. So I'm just wondering, what issues does that raise in the Minister's mind in terms of encroaching on devolved powers? Yet again, it seems to me the schedules don't really have that sort of rosy gloss that the government likes to make out.
Well, that wasn't
in
moved.
Terms of devolved
look, our basic approach to this is we will put in a schedule whatever the devolved administrations ask us to. So DAERA have asked us to put Schedule 4 in, the Welsh Government have asked us to put Schedule 3 in, and we've put in what they asked for.
But you would accept that, I mean, the MPs who put that amendment in weren't members of the government. They were, I think one of them was Scottish, maybe one of them was Welsh, I'm not sure about the other one. But that leaves, this bill, the Agri-Bill, the schedules leave the options open for those sorts of approaches. Would you not agree that sort of, it potentially could impose on devolved powers yet again?
I'm not sure how this works, but constitutionally, because it's devolved, so it's there as a schedule, but because it's devolved, it's something that would probably be deemed unamendable at a later stage of the bill. Certainly the government's view is it's devolved, so we would never support an amendment to either of those schedules.
Right, okay.
And indeed, we had that been moved, we would have rigorously resisted that, and we would in other cases.
Just lastly from me before we do move on from this, I just had a quick look at the Fisheries Bill. We're not here to discuss the Fisheries Bill, but it's just something that I found very interesting, and it says this, and I don't know if the same wording is used in the Agricultural Bill, and it says, observing and implementing international obligations is not a reserved matter. It explicitly says that on the Fisheries Bill. Does it say that in the Agricultural Bill too? And why not, if it doesn't?
I haven't got the Fisheries Bill in front of me, so you have to remember.
It's in the explanatory note, sorry.
In the explanatory note, yes. Well, that is the case, yes, that is true.
So this is just to get to the heart of what this whole conversation is about. Nobody denies that international relations is a reserved matter.
No.
But there seems to be just that little bit of disagreement about whether implementing international obligation is devolved. Now, you've said that very clearly in the explanatory notes for the Fisheries Bill. Is it also the same for the Agriculture Bill?
The reason it would have been stated as clearly as it was in the Fisheries Bill is that a lot of fisheries policy is around international negotiation year after year. And so and we have a particular issue with fisheries, which is that licensing of vessels is devolved, and yet the devolves will be required to license vessels in accordance with a UK international agreement.
So implementing international obligations is not a reserved matter for some bills, but not others.
No,
is it a rule?
No, it's
you
not.
have to tell me if it's a rule or not, because if it's a rule, then
I'm trying to explain why it would have been stated in the way it was in fisheries, which is that those international agreements span right across the area of fisheries, whereas on agriculture, actually, the WTO thing is, from our view, a relatively small, uncontroversial rollover.
The UK government's view on this matter, then, when it comes to the Agricultural Bill, observing and implementing international obligations is a reserved matter. It's either a reserved matter or it's not.
No, I would try to explain that. So there is under the devolution settlement, there is an obligation on the devolved administrations to abide by international agreements that the UK makes as a reserved matter. Demonstrating compliance with those international obligations is reserved, and in order to demonstrate compliance, the UK has to have powers to collect data from.
I'll try one more time. I'll try and put it even more simply just to see if we get a yes or no. Is implementing international obligations a reserved matter or not?
Demonstrating compliance is. Yes, but demonstrating compliance is absolutely reserved.
But it doesn't say in the Fisheries, it doesn't say demonstrate compliance or anything. All it says is observing and implementing international obligations is not a reserved matter. I'm just asking you if that's true or not.
No, that is true. Yes,
Good.
there is, and it's a well-established principle of the devolution
Right,
settlement.
thank you.
But that's, I must add, that's slightly different to the controversy over the clause, which isn't actually about that at all.
Okay.
It's about how you demonstrate and how you're able to demonstrate compliance.
We got there anyway. Thank you for that. Ross Thompson.
Thank you very much, Chair. Minister, as you'll know, there's already some flexibility for the Scottish Government to implement the Common Agricultural Policy differently in Scotland compared to other parts of the UK. So can you give confirmation to the committee this afternoon that the Scottish Government will be able to maintain that flexibility in the future?
Yes, indeed, and they will almost certainly have far more flexibility than EU law currently allows them. So in Scotland, for instance, they've always been slightly sceptical about the process of decoupled support and area payments. Area-based payments are problematic for Scotland because you can have quite wide variances between some of the more moorland and mountainous areas and some of your other upland areas. And so they've always preferred to maintain a coupled payment on the sheep sector in particular. And we, as a UK government, have always supported and argued for that retention for Scotland during EU negotiations. And indeed, they'd be able to in the future. So an area-based payment, as we've had through the CAP, has not been particularly useful for Scotland. And a departure along the lines we've outlined for England, a movement to payment for environmental outcomes, something similar to that might actually work quite well for Scotland, given the variances in the land types.
Yeah. Minister, you'll be well aware that there have been accusations of power grabs, despite no powers being particularly named, but power grabs. Is it your understanding that the Scottish Parliament will have any less powers following Brexit? Can you name any of the powers over agricultural policy that's set to be grabbed?
No, the only power we're grabbing is from the European Union, and then we are giving it back where it rightly belongs, which is in agriculture. It's a devolved policy, and all of the devolved administrations will gain considerably more power than they have now under an EU regime. Thank you.
John Lamont.
Thank you, Chairman. In terms of intra-UK trade, if England moves to a payment for public goods system in Scotland is based on land farmed and food production, have you, as your department, done any assessment as to what impact that would have in terms of the intra-UK trade?
We are looking at this, and it's linked to a separate issue, which is around what would replace ultimately a sort of EU state aid regime. So, we'll either need a combination of frameworks of some sort to be able to agree how we protect the integrity of the internal market. But it's an area where it's possible to exaggerate the extent to which different policies can lead to outcomes. There's already quite wide variance between the devolves in terms of the policies that they put in place. And if you look within the EU, huge variance in terms of what different countries get in the single farm payment. So Holland gets about 3 times as much subsidy as English farmers do. In Poland, it's a fraction of what English and Scottish farmers get. So there's a huge amount of variance within the EU at the moment, despite the fact that there's a single market. So our view is that, given the scales of money involved, you can exaggerate the extent to which spending money in a slightly different way between the component parts of the UK would distort the market. But it is certainly a potential, and we would need to agree some kind of frameworks on that.
And I think you've answered this next question already. I mean, obviously, subject to Scotland and the United Kingdom complying with WTO rules, you're not proposing to do anything which is going to limit the ability of the Scottish Government or the Scottish Parliament you're not trying to limit their ability to develop a policy in this area. It's still going to be very much a devolved policy ahead for the Scottish Government to develop how it supports farming.
Yes, absolutely, it's devolved. Yeah, but as I said, some consideration of a framework to protect the sort of integrity of the internal market. But look, if Scotland decided to continue with something like the existing area-based payment, even though England was doing something different, that would be fine. If Scotland decided to have a lower area payment and put more on a coupled headage payment, then that would also be fine. I guess if you've got to a position where Scotland was saying we're going to pay £500 per lamb as a production subsidy, well then at that sort of point you start to get something that really does distort the internal market. So some of these issues are theoretical, but basically the reality is that the DAs, all of the devolved administrations, will have far more power than they have now to design schemes that will really work for them.
Thank you. Grateful. David Duguid.
Thank you, Chair. Welcome, Minister. We've touched upon common frameworks, and given that agricultural support is one of the 24 areas where the government has identified that a common framework would be necessary, how are the proposed common frameworks covered by this bill?
Well, quite a lot of what we're doing will need concordats or agreed frameworks. So we'll have to put in place something that deals, for instance, with cross-border issues. So there are along the border of both Scotland, but also particularly Wales, you've got farms that straddle both sides. We have arrangements and concordats in place now so that people can choose where they want to be based, and then people supply the data from the relative administration to try and help process that. We'd need to have something similar to that as well going forward. And beyond that, as I said, we want this to be predominantly devolved so that individual administrations can design their own policy.
Can you explain why a common framework is necessary in agricultural support, and what would be the possible implications for Scottish agriculture if a framework were not agreed, and if Scotland were then diverged significantly from the rest of the UK?
I think, if you turn it the other way around, if the administration in England, in DEFRA, decided to do a large headage payment for sheep producers in Cumbria, that would have a big impact on sheep producers in Scotland. And so I think, while we want everybody to have that freedom, I think we all recognise that for all parts of the UK, having some kind of framework where we agree certain parameters of particularly market distorting support will also be quite important just for the integrity of the internal market. So, it's really just having some kind of framework that addresses market distorting support that would actually potentially affect the integrity of the internal UK market.
And it's been said several times in the past, either in the Chamber or in evidence given to us from other ministers, that these frameworks would be agreed and not imposed. Do we know yet exactly what process would be used to make sure we do get agreement on these frameworks?
No, we haven't, and as I said, there will be elements which is a far wider issue, but the what replaces a sort of the EU state aid rules that are there now, and how do we deal with that? And that doesn't just affect agriculture; that affects steel industry and all sorts of other things. So there's an element that would be at that end of the scale, which would clearly be reserved. But then beneath that, we envisage a scope for lots of agreements, frameworks that are done by mutual agreement, by consent.
Okay, thank you.
Just on the frameworks, the government haven't really provided any real detail about what these frameworks would look like. Have you got any idea what they will look like? I know you've got an idea it would be up to 2020 implementation period, but we're all in the dark about exactly what they're going to actually look like in practice. Could you give us any indication of your view about how they would be?
Well, we haven't. If I'm honest, we've been focused initially on getting the agriculture bill through so that we've got the powers to continue to pay farmers the existing scheme, then reform the scheme, and then have the powers in place to start to roll out a successor policy. And we've been open to, there's a huge amount of work going on at the moment, obviously under the EU Withdrawal Act, to put in place all of the statutory instruments that are needed to make sure we've got a functioning rule book on year one. So we haven't, there's been some discussion on frameworks, particularly on fisheries, where it'll be more important that we get it there earlier, and there's been a lot of engagement on that. But on agriculture, we haven't got to the point yet of coming up with detailed ideas about all those frameworks.
Because we're also not very clear just about what the decision-making structure will employ and what degree of influence the devolved administrations will have on them. Again, could you help us with this?
Well, as I said, we've done this work far more on fisheries, where there's a much more immediate concern because we needed those frameworks in place.
Okay, can you maybe tell us what you did in fisheries and how that might apply to agriculture? Will it be the same? Will it be different? Do we need
yes, well, on fisheries, the key issue, as I alluded to earlier, is if we are controlling access in our exclusive economic zone and potentially putting conditions on the access of third country vessels, that might be Faroes or Norway or indeed EU countries, then because the licensing of vessels is currently devolved, the increase in workload for every devolved administration of having to issue 4 separate licenses to, say, Norwegian vessels that want to fish in UK waters would be immense. So you would be duplicating the same work 4 times over. And all of the devolves would be obliged under the devolution settlement to observe that international commitment. So they'd have to give a licence. So there really wouldn't be any meaningful discretion. But at the same time, they've not wanted, for reasons I can understand, to give up what has been a devolved competence, i.e. licensing vessels. So the arrangement we've come to in that instance is that the UK would issue licences on behalf of all of the devolves, because it's devolved, and we would be doing so with their consent because it's devolved. So and that's to avoid the problem of everybody having to issue a licence, so you had 4 licences for the same vessel.
Again, I'm trying to see how this would apply in terms of agriculture. So it would be your view that that type of model would be replicated, and again the Secretary of State would assume the powers just to sort of tell the rest of the devolves exactly what they should be doing and how that should be run.
Well, that's not quite how it works. I mean, that's actually saving them. It's saving them the work. So
you're being helpful to them by limiting their ability to act.
The reality is, it's what they wanted to happen, because they didn't want the administrative burden of issuing potentially hundreds and hundreds, or possibly even thousands of licences, and all the administrative burden that goes with that. They were quite happy for the UK to do it on their behalf, but they wanted, as a point of principle, for it to retain, nominally a devolved matter.
I'm not entirely sure that characterisation is exactly the understanding of the Scottish Government. We'll leave that there just now. Well, on the power grab, you say you didn't understand exactly what that was, you didn't know what the Scottish Government were referring to. Can I maybe help you and see if you agree with this? The power grab isn't about taking powers away from the Scottish Parliament. Nobody's ever said that. The power grab is the fact that powers are returning from the European Union, and there's those that should go to the Scottish Parliament because of the Scotland Act, and they're being grabbed by Westminster. Do you accept that there is an element of that, and that is why we refer to it as it's grabbing as they're returning from the European Union, and they should go to the devolved space instead of being grabbed by Westminster?
Well, I know that's a charge, but we strongly disagree with that. So our view is that where we've sought to have provisions in the bill, these are absolutely clearly reserved matters.
And just lastly on this thing, would the agriculture common frameworks also be with the consent of the devolved administrations?
In some cases, yes. So,
and in other cases, it will be imposed.
Yes, we already have that, but it would depend whether the issue was, obviously reserved, in which case there may need to be some sort of state aid architecture, or whether indeed whether it was devolved, in which case we might still do things in a joined-up way. We do this, for instance, on animal health. So animal health is devolved, but we have well-established frameworks in place, with each component part of the UK buying into the Animal and Plant Health Agency, who coordinate UK-wide work, or GB-wide work, I ought to say, particularly when it comes to things like foot and mouth disease or other exotic diseases. So we have, we can do this. We know we can do it. We have it in place in other areas.
Great. I didn't know if Kirstene Hair was indicating that she was one.
To some extent, you answered my question. The Minister answered. What I was going to ask was, you already have frameworks in place. It is already a practice which we know works for various sectors in the UK. Are you confident that it will work in the same way if Brexit goes ahead?
Yes, provided there's a will to do it. We in DEFRA, perhaps more than any other department in government, do a huge amount of intra-UK diplomacy. And every year at Fisheries Council, we take a whole UK-wide delegation and we agree a collective approach to negotiations to take account of the fact that Scottish in particular have got a very large fishing industry. We do the same in disease and tackling some of those challenges on disease. So we've demonstrated in the past that where there's a willingness to work through differences, we can put in place those voluntary frameworks.
Thank you.
Ged Killen.
Yeah. Minister, what discussions have you had with the Scottish Government about the total levels of agricultural funding post-Brexit as we transition out of CAP arrangements?
So we've been clear, we have a manifesto commitment to keep the budget at exactly the same level as it is now for the duration of this Parliament. That's till 2022. That's the sort of UK-wide envelope. But we have also recently, as you may have noticed, launched a commission to do a review of allocations within the UK. And we've been clear that post 2020, when we get into the new scheme, we would be seeking to take account of that review and work out what the allocations would be going forward. So the global envelope for the whole UK will be the same until at least 2022. But we're also committed, obviously, through the bill to a transition period and in our manifesto to a successor scheme. So there's well, we've not put a figure on it. There's a very clear implication that this will be a funded policy after 2022. And in terms of the allocations within the UK, that's a review that's currently underway.
Grateful. Christine Jardine.
Minister, the bill doesn't contain details of the overall agricultural budget beyond 2022 or how devolved budgets will actually be calculated. So, beyond 2022, how will the UK Government determine the total agricultural support funds to be allocated to Scotland?
Well, look, there is, as with every other area of spending, there will be a spending review period that the Treasury will be working on. Having a commitment to 2022 for the budget is, frankly, more than the European Union have at the moment, because their budget technically expires in 2020. It's also the case that it's more than most other departments have, because in most areas of public spending, as you know, the spending review goes up until 2020. So to have that commitment, and we did it to give certainty and clarity to farmers 2 years ago, we've given that guarantee up until 2022. There will be a funded policy thereafter, but I'm not in a position today to put a precise figure on that. But the absence of a specific envelope or budget doesn't preclude any part of the UK putting in place the legislative powers they need to be able to design the schemes with whatever budget they have.
And will there be some mechanism for ensuring that the money which is allocated for agricultural spending by the UK Government is actually ring-fenced and goes into agriculture?
Well, certainly until 2022, it is absolutely ring-fenced for agriculture. I should point out that there was a slight adjustment that Wales asked for in their schedule, which opened up the potential for the current agriculture budget to be spent on broader rural objectives and even on broader food objectives and supply chain objectives. So they've taken a decision to broaden that out slightly, and that's their choice. It's not a power we think they would use to any great extent at the moment, but it's a power they've nevertheless sought to take.
Thank you.
Thank you. Deidre Brock.
You mentioned the review, Minister. Can I ask, will the principles that are determined by that review apply in post-2022 funding?
Well, in all likelihood. So the issue I suppose we've had with the review is because we only have a guaranteed, the budget guaranteed until 2022, it's looking initially at that. But broadly speaking, I think the answer is yes, in that it is looking at what a fair allocation would look like in the context of emerging policies and emerging priorities. And so the answer is probably yes, the conclusions of that would endure beyond 2022. And the reason we've chosen to do it to 2022 is that's obviously currently where the budget has been set.
Okay. So, I mean, you speak about fairness. I wonder, could you tell us how that review is going to address the issue of the convergence uplift, which, as you'll know, has been a subject of some dispute, and where the Scottish Government states that additional funding for Scottish farmers was ultimately distributed on a UK-wide basis, and the estimate is that around £14,000 per farm was lost as a result of that decision by the UK Government.
Well, look, it's a very complex area, this, but the reality is that the convergence uplift was given to the whole of the UK, and if you look at the figures, Scotland has less per hectare than farms in other parts of the UK, and Northern Ireland has the highest per hectare of all the farms in the UK, and that's largely down to the nature of the soil and a historic allocation. And Scotland, though, because it has larger land areas, it has more upland and moorland areas, it has very large farms typically, the average payment to each farmer was the highest in the UK. So there's been this issue that the average per hectare is lower because there are a lot of moorland areas in Scotland, unlike other parts of the UK such as Northern Ireland. But the average per farmer, because the farm size is much bigger, has been higher. And what we will be looking at, though, as part of this new scheme is potentially saying, let's look at where disadvantages. So let's look at the severely disadvantaged areas. Let's look at the areas, if we're going to adopt a natural capital approach, where you might apply that in a particular way. These will all be obviously detailed issues for the review to look at, but certainly looking at severely disadvantaged areas will be one of the factors they take into account.
But surely that attempt by the EU to level the playing fields by those convergence uplift monies, the fact that money was really available to the UK largely on the back of the conditions in Scotland, and yet those monies weren't given to Scottish farmers, doesn't that suggest we're right to be cautious of the UK making such decisions on Scotland's behalf in the future? I mean, we certainly didn't do well by that one, did we?
Well, as I said, it was a complex issue because the land type is different.
Really that complex, I would suggest. I mean, we've got a far higher proportion of LFAs in Scotland. As I understand it, that's a big reason why we got that convergence uplift money from Europe in the first place.
It was, but the overall UK budget went down. So it's not the case that anybody else benefited from that. The total UK allocation in Pillar 1 went down in the last EU budget round. So there was effectively a levelling off there, but nobody had a rise. It's not like anybody else had an increase here. But look, that's all from 5 years ago now. We are in a very new world.
£160 million.
We're in a very new world where we are leaving the European Union.
Chunk of money.
Where we want to have a forward-facing review. That's why Michael Gove has been really clear that he wanted to get this review in place so that we can actually address this grievance. And I know we've heard a lot from the NFU Scotland have been making the running on this. Many of our colleagues have been pushing very hard for this, and that is why we are going to have this review to ensure that we can address any of these issues of unfairness.
So if the review suggests that Scotland has been hard done by as a result of that decision, will we get the money back?
This is all about forward-facing. So when money's been spent, it's spent. So this is about what we do after 2020.
So no money back for Scotland?
Even
if it's decided that is actually the case?
This is a forward... decision. This is a forward-looking review about how we fund schemes in the future.
Okay, thank you. David Duguid wanted to come in.
I think you've covered the answer to what I was going to ask, which was just get confirmation that at least until 2022, if not beyond, will the allocation of funding reflect the unique challenges facing Scottish farming, such as farming in upland and marginal areas, LFA?
Yes. So as I said, the review that's currently ongoing will be able to change allocations in that period up until 2022. So between 2020 and 2022, we'd be able to have an adjustment in those allocations to ensure that we particularly address issues such as those severely disadvantaged areas.
That's a helpful answer, because the only thing we know about this review is what the Secretary of State said, who said that it would not be subject to the Barnett formula, which in some quarters in the House was celebrated, and some of us met with a sigh of relief that we weren't actually going to be allocated on that basis, which would have been a disaster had that been the case. Is there anything else you could tell us just about how you will look at how these figures will be calculated?
No, not at this stage. The Secretary of State's done a lot of thinking on this, a lot of joint working with the Treasury, And it's been our view all along that it's inappropriate to allocate agricultural support along the Barnett formula. We think it should be effectively a ring-fenced agricultural fund, otherwise you get into all sorts of issues around the integrity of the internal market. And that's what we intend to do, but the precise allocations obviously under review to take account of the new type of policy approach we're moving into.
Just lastly on this, we heard from the Cabinet Secretary yesterday that this was a decision that was pretty much imposed again by the Secretary of State, that there was no consultation with the Scottish Government that this would be taken part, and any input that they would have was not clear and apparent to them about how this would proceed. Could you give them any satisfaction?
Well, I'm sure the review will be very keen to get representations from the Scottish Government.
Okay, right, thank you. John Lamont.
Chairman, I want to just return to the WTO provisions of the bill and the accusation from the Scottish Government that this bill rides roughshod over the devolution settlement. Clearly the provisions around the UK's compliance with WTO rules are quite complex, but there was a useful article by David Bell of the Centre for Constitutional Change, and he said, as far as the WTO is concerned, the United Kingdom Government will be the relevant negotiating authority in relation to agricultural support. If other WTO members objected to, say, levels of agricultural support in Scotland, they would take out a complaint against the United Kingdom under the WTO International Dispute Settlement Mechanism. Is that your understanding too?
Yes, absolutely.
So yesterday at committee, Fergus Ewing, the Cabinet Secretary in the Scottish Government, said in relation to the same point, responsibility for compliance with WTO is already devolved. What has been proposed in the bill is in fact not recognised, and that powers in respect of compliance which are already devolved under the existing arrangements would not remain devolved. I would suggest that that statement is wrong. Would you agree with that?
Yes, because, and again, it's the difficulty is where the UK makes an international agreement or has a schedule at the WTO which is internationally binding, then there is an obligation on all of the devolved administrations to abide by that. And as I said earlier, we see this in fisheries as well. Yeah. If we make an agreement that enables the Faroe Islands to access UK waters, the Scottish Government are duty-bound to abide by that agreement. The difficulty with the WTO is the UK is the body that is responsible for managing compliance with those obligations and defending any challenge that might come. So it is why there needs to be powers for the Secretary of State to have certain requirements in place, and not least through the provision of information and data to demonstrate that we comply.
And I agree with that as well, but just to be absolutely clear, to reassure farmers on my constituency and indeed across Scotland, is entirely open to the Scottish Government to develop whatever scheme of farming support it wants to do, but we need to ensure that we as the United Kingdom comply with those WTO rules, which is why the Secretary of State DEFRA is the Minister responsible for complying with those rules.
Yes, absolutely, and I can be more specific. So I suspect the genesis of the concern that farmers in Scotland have is that they suspect that historically the UK government has been sceptical of coupled payments and has rather begrudgingly defended the right of Scottish farmers to have coupled payments. But I can absolutely say that the coupled payments that they currently have on things such as sheep and in beef in some places to deal with the problems they have with the area-based payments will be allowed to continue. It's simply we have to manage our obligations within that envelope.
Okay. Could you help me with this then? When it comes to WTO, there was a dispute between Angus growers about this organisation operation as a producer organisation. They didn't take the UK government to court. They took the Scottish government to court. Why would they do that if it's totally and utterly reserved?
Well, that's so it's a complex area, but the EU are responsible for designating.
But it's totally reserved, so why would they bother with the Scottish government? It's according to you and your answer to Mr Lamont, it's nothing to do with them.
I'm not sure. I'd have to write to the committee to remember exactly why the Scottish Government ended up being a party to that.
I'll tell you why, because we've got responsibility for the delivery of WTO regulations, surely that's why.
I don't think it is. It's to do with an EU. It's an EU scheme, and the RPA I think the RPA have responsibility, but delegate it back down to the devolves.
Well,
so
I think you're going to have to write to us.
I will
about
write
this,
to clarify,
Minister,
but I think
because
it's...
because
yes.
according to, we could supply you with the note if that would help you in terms of your response, because that was what happened. Kirstene Jardine.
Query for the chair. When you say we, who are you referring to? You said we have responsibility. Who did you mean? Did you mean the
I think
committee?
you meant the Scottish Government. I think you've joined the Scottish Government.
Scotland. Or maybe the
Scottish
Royal
Government,
We is
not us, the
Scotland as
Scottish
a nation.
Government.
I understood what you meant.
As long as the Minister understood me, we got there anyway. Right, thank you for that.
I will write to the committee, though, on the specific issue of Angus Grouse. You're right. We've had lots of legal disputes on the EU producer organisation schemes, and it's a complex scheme.
Yes, thank you. Tommy Sheppard.
Minister, I'd like to go back to the effect and the devolution settlement. You'll be familiar with the Sewell Convention, which suggests that if the UK government is trying to vary the powers of the Scottish Parliament, it will seek the consent of the Scottish Parliament to that variation. Can I ask, is it the policy of your government still to work within the Sewell Convention, or has it effectively been suspended for legislative matters that are relevant to or consequent upon Brexit?
Well, we believe that we've not done anything that breaches the Sewell Convention.
So you're still seeking to adhere to the Sewell Convention?
Yes, and we are adhering to it. And the fact that there might be a difference of opinion about whether a power is reserved or not reserved, that's a whole separate discussion. But from our point of view, where we've legislated, we've done so in reserved areas.
So would you accept in Parts 6 and 7 of the current agricultural bill that the powers that would confer upon you will limit the scope of executive action by Scottish ministers?
I don't think it will, because it's in reserved areas. The one on fair dealing obligations on first purchasers, that is a market issue. It's a competition and markets issue, so that's reserved, and the other one is on the WTO schedule, which we've discussed in great length, which is also reserved.
Well, the limits of agricultural subsidy, for example, that will be limited.
That's right. That decision is a reserved decision.
Right, but that will constrain the executive action of Scottish ministers, will it not? They will have to operate within those parameters.
Yes, they would. Yes.
And given that those are parameters which are not currently in existence, that would be a variation in the ability of the Scottish Parliament to act, and surely that should have, under the Sewell Convention, the consent of the Scottish Parliament to the provisions of this bill should be sought.
Well, my understanding is that there's also a convention that a legislative consent motion should not be unreasonably withheld, and our view is that given where we have legislated, it's
just to clarify, have you sought the legislative consent of the Scottish Parliament on this bill?
Have we?
Have you?
On which issue? On this one?
Yes. On Part 6 and 7.
We've been working with Scottish officials since early this summer. So the clauses on WTO, I think Fergus Ewing said that we hadn't engaged, but they had these in July. We've been engaging with the Scottish Government since May. There's been some 20 meetings with Scottish Government officials. So there's been detailed discussions on these particular clauses.
So it is your view that a legislative consent motion is required in these parts?
And I don't think it's required, but it would be desirable to have, obviously, under the Convention. So we're hopeful still, even at this late stage, although I know that the Scottish Government's taken a view at the moment, rather as a stance that they will, as a point of principle, withhold legislative consent motions on all Brexit bills. We think that's unreasonable, and I hope that they will, on this and on the Fisheries bill, find a way of recognising that a legislative consent motion should be granted.
Okay, I do feel the two governments have a difference of understanding on this matter.
Just to clarify, what we've got is that the Scottish Parliament's view is that consent is required in Part 6 of this bill because, in their view, its purpose is the promotion of an effective agricultural market, which I think we're all agreed is devolved, and not the regulation of anti-competitive agreements, which is reserved. What's your response to that particular contention?
We think it's around markets and it's reserved. So there is a difference of opinion, but that sometimes happens on these issues. But our view is that 25 and 26 are both clearly reserved matters.
Okay, right. Hugh Gaffney.
Cheers. Minister, DEFRA has said that Scotland coupled support programmes for beef and lamb will still be possible under this bill. How can the UK Government offer that reassurance without knowing the share of the EU amber box allowances the UK will receive post-Brexit?
To clarify, coupled payments to Scotland won't be allowable under this bill because Scotland's not got a schedule that provides for them, has powers for them. So, but we would be able, as England and Wales and Northern Ireland, we would be able to make coupled payments under the provisions of this bill. We're at the obviously stages in terms of the discussion around a WTO schedule. We are taking a share of the tariff rate quotas based on historic reference periods, and also a share of the amber box based on a methodology that we've agreed with the European Union about what that share should be. My expectation is that the UK amber box will be in the region of £3 billion, which is probably adequate for us to do what we each intend to do.
Just on that, will Scotland's couple support programme for beef and lamb will still be possible? So you're saying it's only England, Wales and Northern Ireland, it's not Scotland, so it's not possible?
Scotland hasn't worked out yet what it wants to do post-Brexit. And the options open to it are to either add a schedule to this bill, in which case it would be able to continue to make those coupled payments on beef and lamb, or to bring forward legislation of its own.
So would these coupled support schemes still be possible if the UK is subject to WTO de minimis allowances?
As I said, we're going to have an amber box envelope based on a splitting of the existing EU schedule, and we anticipate that will be more than sufficient to cover the types of policies we all want to consider. And that would include allowing continued coupled payments for beef and sheep in Scotland.
So assuming then the UK does secure a proportion of the EU's amber box allowance, how will this allowance be distributed across the UK? Will Scotland get a share?
Yes, and that is what Clause 26 is all about. So the UK holds that schedule, and as I explained earlier, only the UK can deliver compliance with that, and only the UK can decide how we share up that cake, if you like, that share of amber box, to make sure that no other part of the UK is disadvantaged by the policy choices of another.
Thanks. Grateful. What about the red meat levy? I know the Scottish Government and NFUS Scotland have asked that an amendment is brought into this bill in order that this be addressed because of issues of unfairness, which I'm sure you're more than familiar with. Will you introduce such an amendment?
We've got, Colin Clark, the MP for Gordon, who's on the committee, has tabled an amendment, and we've said that we would look at that amendment. I mean, others, I think, as well. Yes, okay, there's probably several amendments.
I know it's customary to always congratulate your Conservative members.
Of course,
Ms. Brock's name is on that amendment too.
Look, the position that we've taken so far as a government is we launched a review of the AHDB. The levy bodies in general, with the agreement of the Scottish Government, and that includes a number of things, looking at how the levy bodies are structured at the moment, how they're funded, whether every sector wants to continue to have a levy body at all. Some sectors, such as horticulture, there's more scepticism about the value of it. But also to look at this issue of the red meat levy. And there's been proposals, for instance, from Wales to change the collection methodology, so that actually you would maybe collect it through an ear tag levy at farm rather than at slaughter, and that means that the devolved administrations would be able to collect money at the birth of the animal rather than the slaughter of the animal. Or the alternative is you create a power, as has been proposed by the MP for Gordon, that you would be able, with consent, be able to move around money between the levy bodies. Certainly, improving the collection methodology is the cleanest and simplest way.
So it looks like, I think what you're saying there is that we could look forward to this amendment being introduced and accepted by government.
Well, we're looking at it closely.
Right, that's as close as we're going to get to some sort of. And just while you're here, you'll know this committee's long-standing interest in seasonal work and the seasonal worker scheme. And since our last report, where we recommended that a scheme be introduced, of course, you would, well, it was a Home Office announced a pilot, but I know DEFRA's interest in this, and it's just your view on this particular issue. 2,500 for the whole of the United Kingdom in the 2-year pilot. Do you really believe for a minute that this is even close to being sufficient? Because my farmers in Perthshire certainly are almost laughing at that type of number to be proposed.
Well, it's a pilot, so it's not the rollout of the scheme. And the source scheme operated from 1945 to 2013, and the quota allowed in under that scheme, certainly in latter years, typically floated between 20 and 30,000, and I think at around the time it was closed, it was moved down to about 12,000. So I think the reality is once we've worked out the pilot and got this up and running, bear in mind we still have free movement with the EU at the moment, and there are still some of the bigger growers are saying that they're able to get the people they need from particularly Bulgaria.
I think it was in response, I think you actually responded to a question which I submitted to DEFRA in the summer, where I actually asked directly in DEFRA's view how many seasonal workers would be required in order to ensure there would be no difficulty in the crop being harvested. The number you gave me was 64,500.
That's based on estimates from the NFU, yes.
No, that was a DEFRA figure. The NFU actually believe over 100,000 is probably going to be required.
I don't think we, because at the moment there are no, obviously there are no permits, so we don't know, we literally don't have precise information because it's not recorded and there's no requirement for a visa. We have no way of knowing exactly how many people come here to do seasonal work. But it is right. So we accept this figure from, and it isn't a DEFRA figure. It's an estimate from the. We have a seasonal agricultural workers transition group, a working group, and that's got all of the industry experts. And their estimate is in the region of so 64,000 might be the precise figure that they have.
I know Kirstene here is interested, and I will bring her into this. But just lastly on this, from me is. Could you give any indication about how the 2,500 will be distributed across the United Kingdom? Is there any view about how that's going to be done? Will it be in pockets like Ms Hare's constituency in Mines, where there's a concentration of farms, or is this to be applied equally across the United Kingdom?
My understanding is, and the Home Office is leading on this, but DEFRA are very involved as well, but there is a consultation out to identify 2 operators to run the pilot.
2 operators?
2 operators. 2 operators, yes.
Okay.
That's not, but as you said, it's a very small number of people. And they've chosen for the pilot to focus it on edible horticulture, so that we've got a sector where we can actually see how this works. And I suspect that the soft fruit industry, because that is the industry that has the peak requirement, as it were, for seasonal agricultural workers, will be
when you say 2 operators, is that 2 businesses? Two effectively agencies who will 2 agencies, yes, right?
2 agencies who will distribute, yes.
Right, okay.
No, we had representations from businesses saying they would like to have a share of it, but because it's a pilot, we decided that having 2 labour agencies who will act as operators to administer the scheme is the right approach for the pilot.
Okay. Kirstene.
Thank you, Chair. I didn't realise I was going to get to speak about my favourite subject. I just wanted to pick up on the 2 operators, because that was obviously how the scheme played out before. You had 2 sponsors, effectively, and so just to kind of confirm on record that was how the scheme operated before, and that's how the pilot scheme will operate.
Yes, there were 2 principal ones, Hops and Concordia in the day, and they were agencies who processed most of the people coming in. But as it was pointed out to me when I went to the group, it was a little bit more complicated in that some of the individual businesses, the larger ones, also had the ability to bring people here directly under the scheme. So there were two labour agencies that dealt with the bulk of the numbers, but there were also some who had an ability to access it directly.
Okay, and I've had assurances from the Home Secretary and from the Immigration Minister, and I'm hoping to get an assurance from you today that this is obviously a pilot scheme, and when it's implemented it is the duty of both members and ministers of both departments, because it's cross-departmental, to monitor the system, and if the industry required, then that could potentially be expanded, but it's very much a case of monitoring closely to begin.
Yes, look, the reality is that once we've gone through the pilot stage and once we leave the EU and end, the presumption of free movement as we've had it, there's absolutely no doubt that you would need to have a significant provision for seasonal agricultural workers. And I said we can't put a figure on it at the moment, but we know that in the years that it operated, in the region of 20 to 30,000 was the numbers that were allowed in, and that included before we joined the European Union even. So we know how it's operated in the past, and I'd envisage it being something similar in the future. But the great advantage of the scheme is you can adjust it year to year. So if we had, at the moment we have a very tight labour market, if in 10 years' time or 5 years' time we had difficulty and we started to have more unemployment, you'd be able to restrict the scheme, and you can adjust the numbers you allow in literally year to year.
Thank you.
Grateful, and thank you for answering these questions. And we're very grateful that the government responded so positively to this committee calling for a scheme to be looked at and introduced. So thank you, and thank you, Minister, for your first appearance. It was very, very helpful, and I hope you enjoyed this experience as much as we did.
I would love to come back again sometime.
Order.
When we went on these issues, the results.
Order. Thank you.